Bismillahirrahmanirrahim wa salatu wassalam ala ashraf al-mursaleen. In this lecture in commercial law for business students for Al Isra University, we are going to proceed in our lectures on page 168 and read: the company is a separate entity distinct from its members. Once registration has been successfully completed, a new legal person is created. Its legal liabilities are entirely separate from those of its members or owners. What the courts have described as a veil of incorporation prevents the members from being held responsible for the company's liability. However, close their connections with it. There are several statutory exceptions to the separate entity previous rule, mainly relating to tax and insolvency law. For example, if during the liquidation of a company it becomes evident that the directors were trading fraudulently, they may be required personally to contribute to the payment of the company's creditors. Fraudulent trading in this context includes continuing to trade when the directors are or should be aware that the company is unable to meet its current debts. Company members may enjoy limited liability for the company's debts. The company has unlimited liability to its creditors, but the liability of its members may be limited. Company law does not permit a company's members to be completely free of financial liability, as this would promote responsible trading. Members' liability for company debts may, on registration of the company, be limited to the value of the capital which they have agreed to invest. Limitation of liability is seen to be in the public interest, since it encourages investment in business and enterprise and therefore promotes the company. Liability may be limited by shares or by guarantee. Liability limited by shares. The majority of companies raise their capital this way if the company is unable to meet its debts. The maximum amount that any shareholders can be asked to contribute in this amount, if any, which they have still to pay for their shares. Their loss is therefore limited to the value of their shares when they join the company. By guarantee, a majority of companies limit their liability in this way. These companies generally exist for educational or charitable purposes, like private schools or communities. Since they are not formed for the purpose of making a profit, it is not appropriate for them to have a share capital. The liability of such a company's members is limited to the amount which they have agreed to contribute if the company is wound up. The guaranteed sum is usually minimal. Exceptionally, a company may be registered with unlimited liability. Its members agree to subsidize the company to an unlimited extent in the event of liquidation. The liability is owed, therefore, by the members to the company rather than the company creditors. The company may be legally liable. Criminal offenses. There are certain crimes like rape where the company cannot by its physical nature commit, Apart from these obvious exceptions, a company may be prosecuted for any crime which is committed in the course of carrying out the company's business. For example, prosecutions are common for using false trade descriptions and for breach of health and safety regulations and anti-pollution controls. The offenses may be committed by an organization if the way in which its affairs are managed A causes a person's death and B amounts to a gross breach of a relevant duty of care owed by the organization to the deceased. An organization includes both a corporation and a partnership. The relevant duty of care covers an employer's duty to employees and contractors, occupiers' liabilities, and duties arising from sale and supply of goods, construction and maintenance operations, use or keeping of plant or vehicles, and any commercial activities of the organization. Proceedings are taken against the company, but its managers and other employees may be called to give evidence. Prosecution is received for the very worst cases of corporate mismanagement leading to death, for which senior managers are substantially responsible. Tort. The company is vigorously liable for the torts of its employees and agents committed in the course of their employment, where the law imposes a non-deligible duty for employees' safety, for example, on the company. It remains personally liable even though the damage was caused by a third party. Breaches of contract. Generally, a company is liable on its contracts in the same way as may other person. Ownership and management. The company is owned by its members and managed by its directors. In a very small company, membership and management may be synonymous, but generally company membership does not give rights to dictate how the companies run on a day-to-day basis. It may not even entitle a member to vote at company meetings, since the rights of holders of some classes of shares may be limited under the internal rules of the company. Public accountability. Once the company has been registered, certain information about it is open to the public scrutiny through the company's registry. This information must generally be updated yearly through the annual report, though unlimited companies are exempt from this. Other company records may be inspected by the public at the company's registered office. The Department for Companies Registry has wide statutory powers to investigate companies where malpractice is suspected. It is legally entitled to obtain a warrant to search premises of the company. A department inspector may require company officials to produce and explain any company document. A report of the investigation is usually made public because it has a public nature. Continuous succession. Once registered, a company continues to exist until the legal process of liquidation brings its life to an end. Liquidation means the realization of the company's capital and other assets of the company or corporation, of course. These are distributed to creditors and shareholders according to strict rules of priority. The shareholders often lose much, if not all, of their investment. There are two kinds of liquidation: compulsory liquidation and voluntary liquidation. Compulsory liquidation, this is done by court order under the Insolvency Act 1986. This most commonly occurs where the company is unable to pay its creditors, who then petition the court. The official receiver is appointed as liquidator. Voluntary liquidation, here the process depends on whether the company is still solvent. If so, the members control the liquidation process. If the company has become insolvent, the creditors appoint a liquidator to distribute the company's assets. The advantages of incorporation as a registered company: limited liability of investors. Investors is a limited liability company are able to restrict their financial responsibilities to the company. They cannot be personally bankrupt to pay business debts.